If I may, my Lord, I'll return to the question that my Lord Justice Stuart-Smith asked just before lunch in due course when I deal with sections 40 and 41 of the Act. If I may begin by, I hope, making something make something clear, if it's not already, that the basis upon which the claim by the Crown Prosecution Service and the court below, that the court should strike out the claim as an abuse of the process, was, as we set out in the skeleton argument in the court below, at paragraph 25, which is in the supplemental, which is at the back of the bundle, the core bundle, where the numbers restart, the tab numbers restart. And it's at 2, and its number within that bundle is, page number is 25.
I'm not sure I got that number. Hold on.
If I'm looking at the right thing, I've got a separate small bundle.
Yeah.
Yes, there should just be, I think there should be just two tabs within it. One is the claimant skeleton argument of the court below, and the second is our skeleton argument in that same court.
Yeah.
Lord, page 25, under conclusions on the scheme at paragraph 48, having summarised the statutory scheme at some length, it was our submission that the following conclusions can be stated from the statutory scheme. First, that Parliament has provided a complete and exhaustive code for the resolution of disputed property rights which may arise between the CPS and a third party. And second, the statutory code fully respects third party rights to ensure property held by them beneficially is not appropriated to pay a defendant's confiscation order. In our respectful submission, neither of those propositions should be controversial, but the one that perhaps is in this context is the first. Because we submitted below, and it's in effect a finding of fact by the judge, not disputed here, that this claim, the only purpose of it was in relation to the Crown Prosecution Service and the restraint proceedings. To make good that point, can I give my lords, and it may not be necessary to go to it because the points are summarised in the judgment. 3 references in the particulars of claim at paragraph 4, which is in the core bundle behind tab 11 at page 87. And these prepared by my learned friend. He says at the top of the page, 87, paragraph 4. In support of the claim, a question has arisen concerning the claimant and the defendants as to the existence and or extent of the claimant's beneficial interest in the property. This case is brought to determine this question. Well, bluntly, no, it hasn't. The defendant, Mr. Tatum, whose presence today is noted by the link, but it's the most interest he has taken in this case thus far, did not acknowledge service, took no active part in the proceedings below. And in reality, there is no dispute as between claimant and first defendant. Mr. Warwick said in his skeleton argument in the court below that in the interests of transparency, the CPS was joined as a second defendant to the claim. But in reality, the second defendant, the Crown Prosecution Service, was really the only party. The point is made by the solicitor in his acting on behalf of the claimant in his witness statement, that's Mr. Beard. That's at tab 14. And he says as much at paragraph 10, but you can find it in the main bundle at page 153. A very short witness statement. And in paragraph 10, he says the claimant brings this case in order to have the issue as to her beneficial interest in the property determined by a civil court. Having received advice, the claimant considers that her interests are better served by bringing a claim in the civil court rather than leaving the matter to, brackets, possibly arise in a criminal court. She does not seek to gain any collateral advantage. One asks the question rhetorically, well, what's the purpose of the claim then, since there is no dispute as between the claimant and the first defendant?
Well, hang on. She issued these proceedings at a time when there was a restraint order, but Mr. Tatum was pleading not guilty, and there were no confiscation proceedings arising.
No, it was after, as you say, it was after the issue, after the making of the restraint order. But at that stage, he pleaded not guilty. In due course, a little later, he pleaded guilty.
Quite a lot later. It was some months later.
It was months later, yes. Yes, her claim, I think, issued in August, and,
Yes.
and he pleaded guilty. But that didn't alter the fact that there was no issue as between her and her partner, the defendant. And it was never suggested that there was actually an issue between them. And his
He didn't acknowledge service and accept that. But why isn't it a legitimate interest for a third party in those circumstances to want to have her interest declared in a binding fashion without waiting on the possibility that the trial may go on for years and the confiscation proceedings may not start for years after that, and they may drag on for another 9 months after that? And we are talking about, at the moment, on the current timetable, confiscation proceedings with a final hearing in August this year.
July, I think.
July,
this year,
August
yes.
this year. There's a rather odd entry which says Tatum adjourned to
Yes, I can explain that. That's because the period has to be, if confiscation doesn't take place at the time of sentence, then the court must then and there postpone. This is section 14, which we'll briefly come to, although it doesn't, not much turns on it in this context. And so the judge, Honour Judge Edmonds, was essentially setting a backstop to ensure that the proceedings were, the confiscation proceedings were kept alive as required by section 14, subsection 4.
And that's almost 2 years after she issues her proceedings. As you accept, she issues her proceedings. He'd been charged, I think, but he was certainly had indicated as not guilty.
He'd been charged and had been arraigned.
Had been arraigned.
Yes.
So why is it? Leave aside the technical argument that it's excluded. If it's not excluded by the terms of the Act, what is wrong with a third party saying, I want to determine in a manner that will bind all parties what my rights to this property are now?
Because so far, there are two answers to that question, my lord. The first is, so far as the scheme of the Act is concerned, it makes it plain, and Parliament indicated that it intended that as far as issues as to realisable property are concerned, which is intrinsically a POCA-related matter, and section 83 gives the definition of realisable property, that those matters should be determined within the confines of POCA and in the Crown Court.
Well, I'm saying just leave aside your argument that a proper interpretation of POCA excludes the possibility of her bringing these proceedings. If we're not with you on that, the question arises, what is wrong with someone, in general terms, wanting to, A, to be a party, and B, to establish in a manner that is binding?
Well, because in those circumstances, the claim is one that is only brought for that collateral purpose, not for any other purpose, a collateral purpose. And this court has repeatedly, Capra and Cheney is an example, but not the only example. And for example, another observations in the case of Hunter, to which we counsel's attention was drawn yesterday, make it plain that in general terms, claims brought solely for a collateral purpose, in other words, to influence another court in a determination, another court of competent jurisdiction, which has to make that, and in these cases would still, and in this case will still have to make a determination.
But if Mr. Tatum and Ms. Ahmet had fallen out, perhaps they'd fallen out about anything,
Yes.
life,
Yes.
it happens.
Yes.
Would you still say there's something wrong with bringing a claim to establish what her rights are?
Lord, without wishing to tempt fate, I'm glad you asked that question. And the reason for that is that it may be less familiar to this court and certainly to my learned friend, but it is absolutely commonplace within the Proceeds of Crime Act, or Part 2, and in particular Section 58. But one of the circumstances where commonly these issues have to be considered is in the context of the Matrimonial Causes Act. And there is no question but that where there is, for example, where there are divorce proceedings and there are applications for ancillary relief, and the jurisdiction of the family courts to make property adjustment orders is in issue, then those are circumstances where, if there is a restraint order, and I make an obvious but important point, all of this is only engaged where there is a restraint order, and in many cases there aren't. In many cases where there are convicted defendants under investigation and convicted, there still aren't restraint orders. But where there is a restraint order, then the Crown Prosecution Service would be entitled to make representations in those proceedings, and the court, as this court knows, by Section 58(5), can stay those proceedings, irrespective of the wishes of the party, or permit them to continue on such terms as it sees fit. And it is common, I should say, for those ancillary relief proceedings to continue, and in some circumstances for property adjustment orders to be made in respect of property which the Crown Prosecution Service may say is part of the defendant's realisable property. The discretion of the family court to do that is not impacted upon by Part 2 of the Act, save that that court would have to have in mind Section 69(2).
So is the answer to my lord's question, no, it wouldn't be wrong?
There are many circumstances where it wouldn't be wrong. And it has never been part of my case that Part 2 of the Act, or that Parliament intended that there should be exclusive jurisdiction in the narrow sense, because aside from anything else, Section 58(5) indicates the contrary.
Yes, but the judge doesn't say that.
Lord, in fairness to the judge, Malone Friend has identified paragraph 33 only.
Yes, I wasn't identifying 33. It was an extemporary judgment, so obviously the conclusions are quite short, but the conclusion is at 57. And that's saying,
yes,
it's an abuse to seek to try the same issue in a different jurisdiction to that which Parliament has decided should hear those matters. Full stop.
Yes, my lord.
That's the finding of abuse, and it's an abuse because there's a scheme.
My lord, reading from the third line down of 57, the only reason for this claim was because of the restraint order.
Yes.
Yes.
Which brings into play 58(5).
But my lord,
So the issue is whether the claimant is obliged to follow blah, blah, blah. So that's a finding, a clear finding that because of the scheme, the claim should be struck out.
Because of the scheme and the fact that the only reason for the claim in the first place was because of the restraint order. And so...
Yeah, I obviously, but of course, if there wasn't a restraint order, 58(5) wouldn't be in play anyway. No. And 58(5) says you either stay it or the court makes directions.
My lord, certainly, as I say, the common situation where Section 58(5) is engaged, and there are, I think one could say, myriad situations where it might be engaged, where there is a genuine dispute between parties, which is independent of the restraint order. So, for example, the victim of a crime may wish to issue proceedings in the civil court in relation to the alleged fraud and seek to establish a proprietary claim in relation to the property, which is respected by section 69(3) in the legislative steer. For example, as I already indicated, there may be divorce proceedings, there may be any number of different circumstances, there may be a lender who has lent money in respect of a property that is owned by the defendant wherein he's not repaying the loan. Now, although on that latter example, there could be an application to vary the order to permit that, and that is, again, entirely commonplace that such variations are made. The lender's right to seek possession is a right that would be effected in the civil courts by a claim. And section 58 would entitle the Crown to make representations where there is a restraint order, but it wouldn't of itself determine it. And section 69(3) indicates that such a claim ought to be, if it's dealt with by way of a separate claim, then it ought to be dealt with. It can indeed be dealt with.
Can I just get the shape of the thing? So it isn't your case that we find in the legislation a code which excludes any civil proceedings relating to property that the CPS thinks might be realisable property. What you do say is what you said below in paragraph 48(1). You say there's a complete and exhaustive code for the resolution of disputed property rights which may arise between the CPS and a third party.
Yes.
So that's what your position is.
Yes. And so...
And just glossing that, you mean arise exclusively between the CPS and a third party?
Yes. Save this case is an example where in truth that is the position, even though it's dressed up to be something different, an ordinary claim between two parties, one of whom happens to be a restrained defendant. I mean, that is apparent throughout the judgment, that important qualification, because Mr. Justice Michael Green, I'm just going to give my lords the references as you would expect. Paragraphs 35 and 36 in particular, but really begins, well, 35 and 36 just for the moment, lords. That's page 72 behind divider 7. At the top of the page, before turning to the case law, it's important to note the reality is that this claim is only between the claimant and the CPS. First, defendant does not dispute the claim. I've said that already. 2, following on from that, if the CPS had not been prosecuting the first defendant and not obtained a restraint order, this claim wouldn't have been brought. And 3, as the claimant said in his witness statement, of a deliberate tactical decision that they considered that her interests are better served by bringing the claim in the civil court. Halfway down paragraph 36, where, having considered Mr. Mullen and Friends' contention that they were just joined, the CPS was just joined in the interests of transparency and quite how it would work, he says, but any suggestion that this is an ordinary civil dispute between a couple as to their interest in the home is wide of the mark. This is all bound up with the prosecution of the first defendant and the pursuit of restraint and confiscation proceedings, which I've already said Parliament has decided should be dealt with in the Crown Court.
Well, you're doing very well until the last few words, which are entirely general.
Well, as between the CPS and a third party, Parliament has indicated that they should be dealt with in the Crown Court, because.
But how does this go forward in this case? If someone, a third party in this person's position, issues proceedings, is the court first of all got to find out whether there's a real interest, not necessarily dispute, but a real interest in the proceedings.
Well, let's just
Because it's not limited to breakdown of marriage.
No.
I mean, you don't have. It's quite easy to play with the numbers to see where the impact of a determination can be powerful both for the third party and also for a person in Mr. Tatum's decision. In one of two respects. One, the available amount might enable him to pay off if he can the whatever confiscation order is made. Alternatively, the larger which is a prospect for collusion, one could say, the larger the amount that he has available, the larger the confiscation order is going to be, and conceivably the longer the period in default of payment is going to be. So the interests go every which way. Not just because they're not at that time saying at loggerheads or in the middle of a matrimonial breakdown. There's any number of worthwhile reasons why.
My Lord, considering my Lord's point in particular in relation to a defendant, could a defendant, for example, issue a claim for a declaration? Could it have been the other way around in this case? Would the court have entertained such an application for a declaration in relation to his proceedings, where he makes his partner here the claimant, but makes her the first defendant? Says, "Well, I want to get a binding declaration. I'm sorry, that I can use to trump any findings in the Crown Court, even though incidentally the Crown Court has different issues to consider, amongst others being Section 77 of the gift provisions, which can completely throw all of this. Because let's say, for the sake of argument, assume for the present purposes that the claimant established on the basis of a common intention constructive trust that she had a 50% beneficial interest in the I'd call it matrimonial home, anyway, the property, largely because I've suddenly forgotten what it's called. Assume she did that. Well, that's not the end of matters, which is one of the reasons why this whole claim is pointless. It isn't the end of matters because the Crown Court would consider first beneficial interest in the property, and this is an absolutely straightforward case. The only wrinkle, in one sense, is the fact that it having been purchased in joint names, there was then a mortgage, and for the reasons she gives, they may be right, they've not been tested because this is also a Part 8 claim, but nevertheless, it was put into his sole name. So let's assume on those facts that she established that she had beneficial interest, joint interest, and there we are. Well, in one sense, so what? Because in the Crown Court, the issues would be a starting point, but it certainly wouldn't be the finishing point. So then what happens?
No, you could still raise issues which were not decided by the civil court,
Yes.
such as tainted gifts.
Yes.
Well, that's not a problem.
But then, what is the value? What is the value of the declaration in the first place on the facts of this case? What's the value of it?
Jumping around, because we're taking you entirely outside your course, but just jumping around for a moment longer. I mean, one possibility that then suggests itself is case management. So one might think that one possibility would be to apply to the civil court under Section 58.5, say, look, it makes no sense for the civil court to go ahead with these proceedings while there are criminal proceedings on foot. The criminal proceedings are much the better place to determine this because, apart from anything else, they'll be looking at the tainted gift provisions as well as the straight proprietary rights. Civil court, do what Section 58.5 allows you to do, stay the proceedings, wait to see what happens in the criminal proceedings. But that's not what was applied for or what has been ordered.
No, because there may be examples where that's appropriate, and indeed Section 58.5 expressly makes provision for staying, as I say, not on the application of either party, but of the court's own motion. And it might do that, but in the meantime, so far as the Crown Prosecution Service is concerned, it has to then leave the Crown Court, appear in whichever court it is that this application happens to be brought, make representations. There's a chance that those proceedings may go ahead, even though the court said, because no doubt the party would say, oh, it's terribly important that this issue be determined, that the court considers these issues, notwithstanding the legislative steer. And in reality, given the context of this claim, where the defendant is now convicted of a drugs conspiracy and money laundering, an offence which intrinsically involves the disguising and concealment and otherwise of property. In circumstances where, as described in the evidence in support of the witness statement, there's considerable evidence of the family living in very considerable luxury. There are real concerns that the process, if there were a green light to parties simply to issue proceedings in this or in the civil courts for declarations, that not only would the Crown Prosecution Service be, or the other prosecuting authority, the Serious Fraud Office, an obvious one, be pulled into the civil courts, because it would have to make representations.
I mean, it obviously would have to, because in the sort of case you're postulating, the real dispute would be between the individual and the CPS or the prosecuting authority.
Precisely, and it's in exactly those circumstances where the judge below found that it would be that if your claim is a claim about realisable property that ultimately is going to be determined in the Crown Court using the procedural mechanism that is available, then in those circumstances, whether they're narrow or not, they certainly apply to this case and any cases where the true purpose of the claim is solely to steal a march on a different court.
And come back to steal a march in a moment, but you say things will have to be gone into anywhere in the criminal court. Plainly, questions of gift would have to be gone into anywhere in the criminal court.
Yes.
If in civil proceedings you had got to judgment and there had been a judgment in proceedings where the CPS was a party, that would be that, wouldn't it? The Crown Court would be bound.
My lord, yes.
Yeah.
But
to
in order
the extent of the civil court's judgment,
Yeah.
which, as you said, would not necessarily take into account tainted gifts.
yes, but bearing in mind that to have got to a judgment or the declaration, the Crown Prosecution Service would effectively have been dragged into the civil court to litigate that, because there may be issues, maybe real issues in relation to it in any event. Therefore, having to not raising the risk of, but actually duplicating proceedings. Because in the end, the fact that the extent of the beneficial interest enjoyed by the third party is an issue that can be and will be litigated in the Crown Court if, and this is another important qualification, if that property is required by a receiver to be realised in order to pay an unpaid confiscation order and not otherwise.
Can I just see?
So can I just
go on.
finish the thought? So in addition, the very issue that my lord posed that could be determined, perhaps usefully, is an issue in respect of which, as I said, the Crown would be pulled into, but may be entirely irrelevant for one of at least three reasons. One is that the defendant is never charged. Two is he's not convicted. Three, assuming a confiscation order is made, that it is in a sum that enables him to pay it without ever requiring the property in issue to be sold. So in other words, the court would have embarked on proceedings which pull the Crown Prosecution Service into them, which may be entirely pointless and which only relate to the restraint order. The restraint order provides a mechanism for that issue to be litigated anyway.
Just as to the last point, you may not need to sell the property in the end. Can the would-be claimant wait till then? Do they not have to come in at the earlier stage when it's being determined what the confiscation order should be? Because at that stage, the judge may determine under Section 10A, may he not, what the interest in the property is.
As far as Section 10A is concerned, a case called Hilton in the Supreme Court, not in the bundle, but it's referred to in Forte, and makes plain that the real purpose of Section 10A is in effect to combine the confiscation stage and the enforcement stage.
There's a reference to that in 40.
In Forte, there is. I can turn it up immediately, but I can find it. It's paragraph 10.
60.
Which is our, in fact, paragraph 11, page 414. And it says in Hilton, the Supreme Court said it was a Northern Ireland case, but it applies to the rest of the Act. Was to combine confiscation and enforcement stages in simple cases where there could be no sensible debate about how the confiscation order should be enforced. So, take a case such as this, where the count, the money laundering count to which the defendant pleaded was £900,000. On the face of it, the benefit from his particular criminal conduct in relation to that count would be £900,000. So, unless there were another pot of money which was available to satisfy, assuming that there was no benefit from count one, the conspiracy to supply drugs, just for the moment. But looking at this, looking at how Section 10A and Section 51 work together, that the court might very well take the view, and indeed has taken the view in this case, so it's helpful to have the judge's directions, that this is a Section 10A case because, sensibly, how else would a confiscation order be enforced, save by the realisation of the property, respecting such interest as the third party has, which is not, well, I say, which is not the result of a tainted gift. So, for the sake of argument, and my lawyers know this very well, how the tainted gift provisions work. Let's assume that the property had started off belonging entirely to the defendant, and he decided, for whatever reason, to gift either 50% or 100% to his partner during the relevant period. Well, then the way the Act works is she would still have that beneficial interest, as it says in Aquila. The Act doesn't change property rights; it modifies them solely. So when it comes to gifts caught by the Act, and not by adjusting the right, but by treating the disposition as being a gift caught by the Act, and therefore including that property within the definition of realisable property, Section 83.
So, I mean, that's all very helpful. Just so I come back, you were saying the issue of the civil proceedings may be irrelevant because it may turn out the confiscation order is in a sum which doesn't require the sale of the property. Now, if you have a situation where confiscation and enforcement stages are merged, that isn't going to bite, is it? Because it's all done together.
Then effectively it's done together, and which is why within Section 51, there is reference back to section 10A. That doesn't appear as regards the management receiver, because the management receiver is effectively the pro tem receiver, and will be a management receiver up until such time as an application is made, because the confiscation order hasn't been paid, and it's not subject to an appeal. So there's no need for an equivalent provision in section 49, management receiver, but there is that provision in section 51 which deals with enforcement receivers. And again, that makes sense within the scheme of the Act. And so yes, in those circumstances, it does bring those two stages together. And at that stage, the third party, as in this claimant, has the opportunity to make her representations. And indeed, in this case, and it's perhaps another example of, we'd say, why this is an abuse. The claimant here has accepted the invitation to be a Section 10A party. And His Honour Judge Edmonds, I mention his name because he was one of the judges in the decision of Forte. And actually, what's significant about that case is it explains, having set out why a third party is different from the defendant in criminal proceedings, then how that difference can be managed in order to ensure there isn't unfairness to a defendant. An defendant is right to refer to the DCF, the Digital Case System. The only parties whom that is available are the Crown, the Court, and the defendant. And that's just the way it's set up. So
a lot of that will deal with the criminal charges, which have nothing to do with the property.
Exactly so, and actually would not only have nothing to do with the third party, but be no business, or might be no business of the third party. So plainly, it's right that they are excluded, but equally, it's right, and His Honour Judge Edmonds, who was within that court, has done exactly that to ensure that the pleadings, section 16, section 17 statements, are all copied to the claimant, so that she's
relevant other documents.
And relevant other documents to ensure that she's at no disadvantage. And with respect, those case management directions within the confiscation proceedings are plainly right, plainly appropriate, and plainly right, because the third party, so far as the issue of determining, and section 10A also is determining the defendant's interest in realisable property in which somebody else may have an interest. So far as that is concerned, that third party, he or she, should not be disadvantaged by the fact they're not a party.
And I follow all that. I mean, it might alternatively be said, you complain about the CPS being dragged to the civil courts. The innocent alleged property holder might complain of being dragged to the criminal courts.
Well, my lord, that's a consequence of a restraint order, and I'm afraid that's part of
statute.
That's statute. Parliament says that, and so long as the property is subject to restraint, and of course that innocent party can apply to have the restraint order varied to exclude a particular property, and it does happen. You know, if third party is able to demonstrate that's mine, not his. Well,
she got the 23,000.
Yes.
Can I just ask you where we've got to? Because I think your submission involves that POCA is not an exclusive regime unless the only dispute is between the third party and the CPS. That's what I thought.
I think my position is that Part 2 is not an exclusive regime, and it can't be because of Section 58. In the purest sense, however, and I think the answer to my lord's question is therefore probably yes, but where there is no other purpose for the proceedings, or no purpose for the proceedings other than in relation to the restraint order, then it's an abuse of the process to...
You went further than that. It's not other than in relation to the restraint order. It's other than in relation to a potential or actual dispute with the CPS
Yes.
about property that is within the scope of the restraint order.
Yes.
I'm going to ask you the unfair question, which is, at some stage, where do we see that it is an exclusive regime in proceedings relating to restrained property, where the only issue is between, as you would put it, between the third party and CPS?
My lord, I think I'm going to go back one step, because I quarrel with the word, exclusive. Exclusive isn't a word that featured in our skeleton argument.
Exclusionary.
We used the word exhaustive deliberately, because it does provide an exhaustive system, an exhaustive mechanism.
It may do, but the question,
Yes.
one of the questions we have to grapple with, it may provide an exhaustive system. The question is whether it's an exclusive system in the sense that any other way of doing things is not permitted, which my present understanding is common ground, that that's a matter of interpretation of the statute.
Yes.
And speaking entirely for myself, if I had to write down now what it is in the Act that leads to the conclusion that Part 2 is not an exclusive, in the terms that I'm using it, regime, unless there's no purpose to the proceedings other than in relation to property subject to restraint order, I would not be able to do it.
I mean, if the way that the court can protect itself, and this was the heart of our application, the court below, the way that the other courts can both protect themselves and ensure that in respect of disputes in relation to realisable to property subject to restraint, but where they are properly characterised in the way that I have, then it's an abuse of the process of this court, the definition of which, or the scope of which, is very wide, because the purpose, indeed the only purpose of the claim, is a collateral purpose.
Collateral because it avoids going to the Crown Court.
Well, it doesn't actually avoid going to. Well, yes.
May do.
Yes.
May do.
Well, my lord.
Can I test it at its limits?
No, with respect, it wouldn't. Even then, and I hesitate to quarrel with my lord, but
don't hesitate.
the reason for that, and it's made plain by what Lord Justice Hughes, as he then was, said in Stamford at paragraph, I think I won't guess the paragraph, 133, I think, which is that while property is subject to a restraint order, then the only court that can deal with the restraint order is the Crown Court. So the blunt answer to my lord's question is no, that's wrong. You'd still have to go back to the Crown Court. Now, it may be that you would then be pushing at an open door, because if, for the sake of argument, there were a declaration. But nevertheless, that's why Lord Justice Hughes said, and I'll need to turn to it very briefly to make good that point. That's why he said, it's page 333, paragraph 205. And the court's already been taken to this section. The jurisdiction in relation to restraint orders is in the Crown Court. Same court is the only jurisdiction to vary or discharge a restraint order once made. That's section 42. Subsection 58.5 plainly contemplates other litigation related to property, which is the subject of a restraint order may, as a result of the order, need to be stayed or permitted to proceed. Accordingly, the initiative is firmly in the hands of the Crown Court, and it's that, with respect, that we submit is what Lord Justice Hughes was there talking about.
But I don't quite see how, I mean, it's a question of what he meant, but when an application is made under section 58.5, the initiative is not in the hands of the Crown Court. It's up to the civil court to decide what to do.
But, my lord, that's an initiative which that isn't. The Crown Court, the High Court, the Civil Court doesn't have a free hand, because it's bound by section 69, subsection 2.
But does that really take you very far? we look at section 69,
That's in divider 1 at page 84.
so 69.2, I mean, I don't think it's in dispute, as I understand it, that this applies where you're deciding what to do under section 58.5.
And indeed, my lord, it does. Yes.
So 69.2 says you have to exercise the power with a view to the value of realisable property being made available. But then section 69.3 says you have to do it with a view to allowing a person other than a defendant or recipient of a tainted gift to retain or recover the value of the interest. I mean, does it take you very, very far when you put the two subsections together?
Well, it's part of the way that Parliament indicated that there was a strong legislative priority in removing removing from defendants assets that fall within the definitions, various definitions in Part 2 of the Act.
And also a strong legislative steer that if it's not within the scope of the Act, then the person should keep it.
And that, yes, I mean, certainly that's the effect of section 69.3. Although in the context of this claim, the claimant is somebody in respect of whom it would be said, and is being said in the confiscation proceedings, that she is the beneficiary of a gift.
Can I just test them?
So to that extent, she doesn't enjoy the but her protection is more or may be limited by that.
Can I just test the limits of it? So you can apply for a restraint order when you've got an investigation.
Yes.
If there's reason to believe that the person under investigation might have made money out of it.
Yes.
As you'll appreciate, I don't know that much about how this works in practice, but I can imagine there are cases where you apply really early on.
Yes.
Because you fear that this person will otherwise dispose of their assets. You know, in a civil context, you do that all the time at the beginning because you fear that otherwise the assets will be gone.
Yes.
Now, there must be cases where there are complicated investigations, and even when the investigations are concluded and you get to the stage of charges and criminal proceedings, well, criminal courts, those of us who are civil practitioners understand, can take a very long while to reach a conclusion. It could take years. And then you have someone who thinks they have a perfectly good claim to an item that the CPS think might be within the scope of realisable property. And they think, I don't want to wait all that time. Is it necessarily abusive for them to come to court and say, look, we don't want to wait. We can get a resolution from such and such a court in the space of a year. Let's do it.
It's likely to be, my lord, and it's likely to be because by section 42, that person is entitled, as a person affected by the restraint order, to apply for its variation or discharge, and that right is backed up by a right of appeal to such person.
But that's circular.
I'm so sorry.
To my ears, that's circular. The fact that unless you're saying that section 42 demonstrates that it's what I call an exclusive regime, that's not an answer to my lord's question. Because my lord is saying, let's assume that the person, as I understand it, let's assume that a person has a real interest, not in a strictly legal sense, but has an interest in getting a rapid determination. And, for example, she may wish to dispose of the property, to go and do whatever she wishes with it.
Yes.
I accept there's a difficulty with tainted gifts. But unless you can say that proper interpretation of the statute means that this is simply not open to her, it's not an answer to my lord's question, I don't think.
I mean, as soon as you stick in the word likely, it doesn't sound like an exhaustive regime. It sounds like something fact sensitive.
my lord, page 44, the authorities perhaps ought to look at what the subsection says.
Yes.
Subsection 3. An application to discharge or vary a restraint order or on the grounds 41(7) may be made to the Crown Court by the person who applied for the order or any person affected by the order.
So help me as to how it works in practice. You have this situation where there's a property held in the name of the potential criminal defendant,
Yes.
but an individual says, I have a really strong claim to an interest in this property. Is it going to help that person to apply under 42(3), or is the court going to say, we're really not going to go into that at this stage, we're not going to undertake everything that would be necessary to determine your rights in this property?
Well, in answer to your question, I'd say it may be. It may be for this reason. Let's assume, for the sake of argument, that not this case, but a case involving the matrimonial home, where it's been conveyed into one name, and the other party says, "Well, common intention constructive trust. I've got 50% interest." The defendant, who, let's assume on my hypothetical, is the sole breadwinner and the person who is paying the mortgage, but whose income makes that possible. And the defendant, husband of my example, is remanded in custody or sacked, both of which are common
Yes.
in this realm. Assuming there's no other fund available to pay the mortgage, in the exercise of its discretion as dictated by or powerfully influenced by section 69(2), the court would then there would be a variety of ways to meet the justice of the third party's claim. One would be to ensure that, for example, if there were other frozen funds available, those should be used to pay off the mortgage in the meantime, so that its value is retained, and so that the third party and family can continue to live there. Another would be for her to say, well, the only realistic way I can do this, given that he may never be charged or may be acquitted, is to borrow against my share of the property, assuming that were possible. In which case, the court would need to determine this very issue then and there. And if it refused to, or if it ruled against it, then she'd have the opportunity, she'd have a right of appeal. So there's a practical way, because a practical way of at least providing that party with a remedy within the Act, with rights to make representations. And at this point, I'll answer my Lord Justice Stuart-Smith's question just before lunch. In the event that she was successful in her application to vary the restraint order, and it had been opposed, then she's entitled to her costs. Give me just for a moment. Criminal Procedure Rules, Rule 3347, in effect.
Sorry, criminal procedure rules.
I'm so sorry.
PR
3347.
33 subparagraph 47.
Yeah, brackets. Yeah. Either way, if point 47. A successful party on an application to vary a restraint order or order made in enforcement receivership proceedings is entitled to seek costs, and taking it shortly, the Crown Court applies the general rule in CPR 44 to the costs will ordinarily follow the events. And so Criminal Procedure Rules 3347 it broadly mirrors 44.2.
Thank you.
We've taken you completely out of your course. I think we've covered quite a lot of ground, but to ensure you actually get through your submissions in the time allowed, we better let you develop them as you wish rather than being blown this way and that.
And I hope that it's noted that it's not my fault. Because it's so rare that it's not my fault. That,
I'm sorry that Lord Justice Coulson is taking up so much time explaining this.
Whatever the outcome, we won't blame my Lord Justice Coulson.
I will.
My Lord, I hadn't got very far, but the helpful questions from the tribunal have narrowed the issues at least somewhat. What I did though want to do is to give you the references, because it is important, because we say that the basis of our application for a strikeout was actually a narrow one, because we acknowledged Section 50, the impact of Section 58, and indeed it's an obvious point that is referred to in the Aquila case, that the POCA doesn't change property law. It acts sort of as an architecture that permits the Crown Court to do certain things, and in particular in relation to confiscation and enforcement proceedings, to make certain assumptions in a similar way to the Insolvency Act, where there are dispositions within the period leading up to insolvency or bankruptcy. It's effectively the same system. But my Lord, yes, to make good my point, although my Lord Friend was at pains in his oral submissions before you not to be critical of the ability of Crown Court judges to make decisions in relation to beneficial interests and the like, which we respectfully submit are day-to-day occurrences within the confiscation. In his skeleton argument, in fact, in this court, divider 3, paragraph 2, he does put it rather differently. On behalf of course, on behalf of the claimant, at the top of page 19, paragraph 2, she, the claimant, believes that a Crown Court judge, knowing the co-owner of property, D1, is an admitted drug dealer, will consciously or unconsciously determine factual and legal issues adversely to her in order to leave D1 with a larger beneficial interest, with the result that more money is available to be taken away via a confiscation order made under the Act. Now, whether that's what she thinks or not, it's not a relevant matter, as my Lord Justice Coulson has already observed. Within within POCA, the Crown Court judges are well able to deal with these matters. And I mentioned just in passing, because Southwark Crown Court was identified. It's certainly right, as given that Southwark Crown Court is the principal fraud court, not in the country, certainly in London. A lot of the decisions in relation to Part 2 come from that court. And this court may be interested to know that the current resident judge, the Recorder of Westminster, His Honour Judge Baumgartner, is also a Chancery judge and sits in the High Court, and indeed in the recent case I've done sat in both. But that doesn't mean that it would be appropriate to exercise Section 58.5 in a matter which is intrinsically a restraint matter. What it does indicate is that whether directly or indirectly, the Crown Court has the capacity to ensure that cases are determined by judges with the necessary expertise. And whether that's by identifying a judge who's already in the Crown Court, a circuit judge in the Crown Court, who is familiar with these issues, or whether it's necessary to bring in a specialist county court judge or indeed a high court judge. All of these things commonly happen. What I can tell you doesn't commonly happen is is the obverse of that appears in the postscript to the SFO and Lexi Holdings case, where the proceedings in the Crown Court are somehow delayed or suspended or stayed so that the matter can be determined, for example, in the Chancery Division. It might happen, but I don't know of a single example where it has. But I know many examples where a specialist judge is appointed to deal with the particular issues in a complicated case. So again, there's a practical solution, but I still haven't got going. It's a rather dismal prospect for everybody. What I wanted to say, and Lord Justice Coulson took me to the conclusion, but the conclusion and the judgment, or the concluding remarks, do refer, and it's important that they are seen in the context of other findings that Mr. Justice Michael Green made, and we see at 32, because my learned friend pointed out 33 and talks about rightly the exhaustive code, but in the very paragraph before that, paragraph 32, there deals with section 58.5, which necessarily has an impact on any assertion of exclusive jurisdiction, but then says, to my mind, and this is halfway down, to my mind that indicates Parliament was assuming the primacy of Crown Court proceedings. There may be any number of other pending proceedings concerning relevant property, but account must be taken of the restraint order and the CPS has to be heard. Section 58.5 does not give the green light to a claimant such as the one before me to start proceedings in this court following the making of a restraint order. And then at 34,
I don't think anybody is disputing the primacy of the Crown Court proceedings. Obviously, that must be right, because 58.5 says, as a result, you might have a stay, you might have homemade directions to deal with it. But what it doesn't say is you strike out because you don't have the right to bring the claim.
No,
that I think is the issue. Nobody disputes the primacy point.
But I come back to the point, and perhaps it is my answer to it, which is that there will be the spectrum of cases that there are, which involve property that's subject to a restraint order, will be wide, varied, and no doubt colourful. But in the category of case such as this, it is an abuse of the process because the only reason, and it's not an acknowledged reason, the only reason for it is to try to achieve some advantage in the Crown Court, which is available in the Crown Court anyway.
When you say advantage, you have one judge with a Crown Court hat on and you have one judge with a High Court hat on, and the one or other of them will decide it. What's the advantage of it being one over the other?
Well, the advantage of it being in the Crown Court is because those issues are going to have to be determined anyway in the event of conviction.
They don't want to do that. They want it to be a High Court judge. What's the advantage? What's the march that's being stolen?
Well, in the present context, first answer to my Lord's question, in the present context, there is absolutely no advantage to the claimant for her claim to proceed in any event because it won't result, for example, in the variation of the restraint order.
So it's not stealing a march.
Well, it would have to be right that the purpose though of it is so that she can have an issue determined in one court which is not otherwise concerned with the issue over the determination that is made in a court where that is an issue before the court already. And it's an issue because of the existence of the restraint order.
Yeah, but how's that an advantage? Say the High Court judge says beneficial interest 20%. And then off to the Crown Court to deal with all the things that the Crown Court deals with. So the Crown Court judge has one less thing to deal with because the beneficial interest has been fixed at 20%.
Well, I've already indicated that there's the practical issue, which is that matter will have required the Crown Prosecution Service to make representations.
That's a
And
different.
there may be issues. There may be issues in respect of the evidence, that is evidence which is which may impact, for example, on the criminal investigation. There may be matters because if my lord is right, then as soon as a restraint order is obtained, even though the restraint order, I'm sorry, let me slow down. My lord is right, then somebody in the claimant's position, or possibly for the reason I've already said, a defendant's position, if it is available, if it's a free-for-all, then an application could be made soon after a criminal investigation, as soon as the restraint order is applied for, even though there may be matters being investigated in relation to the defendant that may, for the sake of argument, include, if it's a money laundering investigation, may concern the very property that's subject of the criminal investigation.
Yeah.
In which case, then it's difficult to see how the reason for an application in the civil court could be for any other purpose than somehow to try to influence or dictate what happens in the Crown Court. Because anything practical can be dealt with within section 42.
But to dictate a wrong answer, a false answer, an answer that the Crown Court judge wouldn't come to, it's just that I'm exploring. There's no explanation, but I mean the judge uses the expression "stealing a march," and you have, and I was just anxious that I understood what advantage it was, because it's quite difficult to identify, I think.
Well, the question of beneficial ownership may impact upon the gift question, although it shouldn't, but it might. If, for example, the defendant, and those questions aren't going to be known, but in the meantime, let us assume that it is a gift situation. The point about property that in the hands of a donee of a tainted gift is that it's treated as the realisable property of the defendant. So on the practical example that I proffered in answer to the question from my Lord Justice Newey, if a person, for example, wanted to borrow money against a beneficial interest in property, which actually had been entirely given, or it was a disposition made not merely within the relevant period, but to frustrate the confiscation proceedings, that there would then be an advantage to that individual, because they would say, well, this is mine, I've got a declaration, I can go to the lender and I could say, here's a declaration in relation to to my interest in this property, and I'd now like to borrow up to the maximum I can against it. And then that borrowing would be secured by a charge against the property, which is a right that would be protected by section 69(3).
You can, if in the situation you're suggesting, the CPS or anybody else who wanted to challenge it, a lender or whatever, could come along and say, this is a sham transaction to avoid the consequences of his criminality, that would be an argument that would be available in the civil court. The only thing I think you've identified so far that might not be available is the tainted gift provisions, because they are specific to POCA.
Yes.
Otherwise, at the moment, I can't identify anything I understand the procedural disadvantage of CPS being, as you put it, dragged to the civil courts. That I can understand. But going to my Lord's question, what advantage or disadvantage? I can't at the moment see much apart from tainted gifts and the fact you might have to have 2 hearings instead of 1.
Look, the financial investigation at the time the restraint order is made may be in its infancy or not have begun.
But it has to satisfy, it has to have gone far enough to satisfy a judge to impose a restraining order.
So far as the imposition of a restraint order is concerned, the focus is whether the defendant has benefited from the criminal conduct. It's not, and so in a case such as this, where there is evidence or there was evidence that the defendant had done so, that didn't depend upon questions in relation to the property. That related to matters intrinsic to the criminal investigation. What is, and it was demonstrated that there were reasonable grounds to suspect that he benefited. The question of the restraining property is a completely separate question, and the investigation need have gone no further than to establish, and that's what happened in this case. The defendant was the sole proprietor of Brindle's House Farm, and the restraint order was made. So there's no indication that the financial investigation, if it existed at all, was in anything other than its infancy, and that would be common. And the alternative is that somehow that the Crown Prosecution Service would need to have all its ducks in a row at the time of applying for a restraint order, have a full a financial investigator running alongside the criminal investigator or the investigation in order to head off any challenge made in a different court after the restraint order is made. So I'm sorry, a long-winded way of coming back to my Lord's question about stealing a march. And I'm sorry to, in one sense, sorry to say this, but in the context of criminal restraint orders, they are made because individuals are suspected of criminal conduct, which puts them, they may be wrong and they may not be charged, but it puts these cases in a different category to other cases. Of course, I'm very well aware that in the civil courts, there are fraud trials conducted where, to all intents and purposes, is a criminal allegation. But the reason for restraint orders, in the first place, is that those accused of crime, at the very least, it may be that they're rightly accused of crime and that they may have a very active interest in seeking to frustrate the making of a confiscation order. So, to answer the question, I cannot reel off a deck of answers to the stealing a march, but I don't. What I certainly don't accept is that claims such as this do not intend that purpose and could achieve that purpose.
And again, you've been covering useful ground, but again, I'm conscious that you're not being allowed to move forward and time is passing. So
yes,
that was my so we'd better let you make some progress.
Would you forgive me just for a moment?
No.
Yes, yes. I'm right. I don't want to go back to what we've just been debating, but I'm provided with a helpful note. You said assume maybe that a defendant used the proceeds of crime to contribute towards the purchase of property, and then the advantage to the third party would be to profit from his criminal activities if it's established. And again, to use the paradigm example, a 50-50 division of a property that was itself purchased with the proceeds of crime. And that's why, in the end, correct myself, it's our submission that that's why Lord Justice Hughes made the point he did in Stamford about the Crown Court having primacy. It's because ultimately the decisions in relation to whether, the decision as to whether to vary or discharge a restraint order is a decision that Parliament has given to the Crown Court only in section 42. My second point was going to be the procedural inconvenience point, but I think effectively I have made whether made good or at any rate made it. I have. So far as the statutory provisions are concerned, other than seeking to the extent needed to explain how the different pieces of Part 2 fit together, I wasn't going to make any specific points, but that mechanism recognises that so far as the impact on other people who have or may have an interest in property, but ultimately it's at the enforcement stage. That really leads me on to the first of the authorities that Leonard Friend particularly relies on, the case of Norris. You will find it divided 8. You will have realised that and know that under the previous legislation, Drug Trafficking Offenders Act, Drug Trafficking Act, 1996, Criminal Justice Act, Part 6 of the Criminal Justice Act, 1988, the jurisdiction for making, or jurisdiction to make restraint orders was in this court, and the jurisdiction to appoint receivers was at, I say this court, in the High Court. And that was changed, deliberately changed by the Proceeds Crime Act to put the jurisdiction in the Crown Court. But it's essential to have that in mind when considering what, in particular, Lord Hobhouse was saying and why he said it in Norris. And begins on page 166. There is a part of the head note which is particularly important in our respectful submission at E, which shows the context in which the application was made. The judge appointed, this is in the High Court, the judge appointed a receiver to realise the defendant's assets, and having made a declaration that the defendant had the beneficial interest in the house, included that property in the schedule of assets to be realised, the wife made an application to vary the order on the ground that she had an interest in the house and sought to give evidence in support of her application. So the application made by the wife was in the context of the receivership proceedings under the DTOA. It wasn't a separate freestanding application for a declaration. That jurisdiction is now in the Crown Court, but the ability of the third party to make such representations is preserved. And if the court has been satisfied that it's a 10A case, then those rights are within 10A. So Norris isn't support for the proposition that there's a freestanding right of a party, or that it would be appropriate for in a case such as this to seek a declaration, because it was emphatically tied to the criminal context, and that's made expressly clear in our respectful submission, page 179. It's the tail end of paragraph 25 that starts on the preceding page. But at E, Mrs. Norris is not misusing the procedure of the High Court. She's making the proper use of the civil jurisdiction of the High Court to protect her proprietary rights as the 1986 Act contemplates that she should. So this claim was brought within, and the claim approved by Lord Hobhouse in that context, in exactly the same way as now a claimant such as this one would be entitled in the event that there was ever or it was claimed that there was a need to realise the property. So it isn't, we respectfully submit support for the proposition that it is relied on for by my learned friend. Before looking at the other authorities, can I agree with the observation of Lord Justice Coulson in relation to 41(1), the specified person. It's not defined because the specified person is the person who's identified in the restraint order. The power to make a restraint order applies to a person who's specified in the order. And in fact, in this case, because as a matter of interest, I meant to say it before, because the properties in the property which is in issue is in the sole name of the defendant, it's identified as his asset. So far as the claimant is concerned, she is mentioned in and is specified in the restraint order, but only in respect of the jointly held bank account, because that's the one which, on the face of it, she had an interest in. So specified person is not a term of art. It's a term of context. And I think I've already made the point within section 49(2), powers of a management receiver are limited and don't include a power of sale, save where necessary to pay the expenses of the receiver. And subsection 8 limits the ability of a third party to make representations, and in particular limits it to circumstances where there may be perishable assets that have to be realised, otherwise they'll become valueless. In marked distinction is paragraph 51, the powers of an enforcement receiver, which do include a power of sale. And at that stage, as I say, a third party, subsection 8 and 8A, is entitled to make representation. I'm not going to go back to it, but in Norris, I should also have referred my lords to paragraphs 14 to 16, which I submit support the analysis which is summarised in paragraph 25 of the different stages within the restraint, confiscation and receivership proceedings, but there's no need to go through them in particular. But it would be useful at this point to jump forward in time because of the reference to the Aquila case, and it's our submission that the passage that is relied on by the learned friend at 394 at G, reference to Norris, doesn't take matters any further, and again doesn't support the proposition for which it's advanced. Starting just below F, in this respect, Parker reflects the approach of the Drug Trafficking Offences Act, which preceded it, of which Lord Hobhouse said in setting out the scheme of that Act, paragraphs 12 to 17, that confiscation orders should not interfere with property rights of innocent third parties. That's just an ordinary statement and reflect what's in section 69(3), and not saying anything more than that. And part 2 does exactly that, which was a feature of the antecedent legislation. I've mentioned already the SFO and Lexi Holdings case and the postscript. The case involves no tab 10. The postscript appears page 252 and 3. And already submitted that notwithstanding that the court there was envisaging other cases where the complexities are such that it may not be wise for the Crown Court judge, this is the sort of page, to embark on seeking to decide those issues. In such cases where a relaxation of a restraint order is sought, consideration should be given to adjourning those proceedings. And so on. The passage has been read out. The qualification on that is, we say, in what Lord Justice Hughes said in Stamford, page 333, paragraph 205, the initiative will always be, or will and should be, that of the Crown Court. And it would involve the Crown Court judge saying, well, such are the complexities that it's necessary for us not merely to, for this court rather, to ask for the assistance of a High Court judge, which would achieve, one would have thought, exactly the same, but to adjourn those proceedings. As I say, I'm not aware of it ever happening, and more to the point, I'm not aware of a case where that has happened, where the issue has been gone on to an appellate court. But it is common for, or relatively common for assistance of the senior judiciary, the High Court judiciary, to be brought into restraint-related matters. And of course, at any rate at Southwark, there's very often a High Court judge in the building in any event, not all the time, but there often is. And matters are on occasion listed in front of those already busy judges. So I don't think, certainly I've got no further submissions in relation to the postscript. And it isn't, as it were, the green flag to this sort of application. Stamford, it's not just the paragraph I referred to, 205. The court went on, and Lord Justice Hughes went on to page 3 and on page 334 in paragraph 208 is set out there the postscript, but also the qualification, and it may be that this is the qualification Lord Justice Stuart-Smith had in mind when talking about the abilities within the Crown Court system, because Lord Justice Hughes says judges in the Crown Court should not, of course, shrink from deciding issues of civil law where they properly can, even if they're less familiar to them than is the daily round of the criminal jurisdiction. But there will be a few cases, the complexities of such are such that the Crown Court judge should not fear to explore the possibility of onward allocation to another judge. Legal complexities may be a property law, equity, etc., etc. Even in such case, the judge in the Crown Court will ordinarily have to deal with the initial application, and that's the point about case management. It's perfectly open to the Crown Court. It would have been open to His Honour Judge Edmonds in this case, although this is far from a complex case, but it had been open to him in the context of the Section 42 application, the variation application, which actually there was a variation application made by the claimant, but in the end it only went ahead in relation to the joint account and not to this. But she availed herself of at least part of it. But it would have been possible for that court to say, well, in that case, and it, perhaps again circling back to the point about the forum convenience, that actually it would be the Crown Court, and if it needed any assistance, it could get it and give case management directions to that effect. on the Ghulam case, which is tab 13, the court, certainly the sidebar reference, page 371, paragraph 90, relied on Weimann and a friend, our submission in relation to that. This does nothing more than state what the law is and say that in relation to section 10A, it's currently in its infancy, or was at that time in its infancy. But the point being made is that, or the point to make is that the court does not embark on section 10A, a 10A determination in every case, far from it. It only makes it if it thinks it's appropriate to do so. And if it doesn't make a section 10A application, that's not, oh, over to the civil court. That is, well, let's see what happens. Let's see whether the property is ever taken into account, whether it needs to be sold, putting it bluntly, and it may not. The Fort case, divider 16, we say that the same point is made. Page begins at 410, that the passage relied on, I think, by Malone and friend was paragraph 10 on page 414. And this perhaps is an important point because there's been some discussion as to quite what the status of a third party or an interested party is. And Malone and friend made the point, well, you can't join the interested party isn't joined. Well, there's a very good reason for that, and indeed one can see that third parties wouldn't want to be joined because joinder in a criminal context means something very different. The proceedings in the Crown Court, this court very well knows, are between the Crown and the defendant. And
to be joined in criminal proceedings, you have to be the subject of an indictment.
My lord, yes.
Which possibly the judge overlooked when he talked about joinder.
Yes. But as my lord, as has already been observed, it was an extemporary ruling. I would have certainly had something to say if the proposition were that you could simply join a party. They're not joined because they could only be joined as a defendant, but provision is made for them to be an interested party. And one of the reasons, apart from the obvious one that they wouldn't want to become a defendant, is that the issue being determined is the defendant's interest in the property in question, the extent of the defendant's interest in the property in question, and ultimately the value of that.
The trouble is, it can end up with the property being sold.
Yes. Yes. So the observations. But it's a as it were a distinction without any difference. It's certainly right that the interested party, section 10A, is not made a defendant. Clearly. But the reason I say it makes no difference is because what Fort does is to set out some of the ways that the court can, or steps the court can take to ensure that a person who is seeking to prosecute their own claim in relation to an interest in property in the Crown Court is not at any disadvantage simply by not being specifically referred to, not having access to DCS, not initially being a party who has to provide either a section 16 or a section 17 statement, because those are only the Crown for section 16, the defendant section 17. That's why section 18A was introduced at the same time as section 10A, so that the interested party can be directed to provide information in relation to the question that's subject of the 10A ruling, or maybe the subject of a 10A ruling. So they have the opportunity of, in effect, joining the pleadings and then being provided, as happens in this case, with the documents. And the references to may or might in this and in the case of Ghulam, not we submit indications of separate proceedings in the civil court, but rather a reference to the discretion on the Crown Court whether to embark on a Section 10A determination or simply to leave it to the enforcement stage in the way that Lord Hobhouse was talking about in the Norris case all that time ago. And of course then there was no 10A, obviously enough. And that brings me to the case, my sheet anchor, as described, Catherine Cheney, Pack 12. The 2 points that I particularly want to make. Mr. Justice Lewison, as he then was, plainly relying on support the autologic case and reasoning in respect of Part 5 proceedings, and in particular cash. And can I just really by way of explanation, page 338, paragraph 5. The court, I'm sure, appreciating this already, but where Mr. Justice Lewison said 2 points emerge from this. First, Pocket allocates jurisdiction in respect of recovery of property to the High Court, but jurisdiction over forfeiture of cash to the Magistrates' Court. In other words, that's a reference to Part 5. Civil recovery proceedings are reserved to the High Court, and cash, and now account freezing and account forfeiture, and similar powers to the Magistrates' Court. So it's only in respect of recoverable of civil recovery that the High Court has jurisdiction. That's what that's a reference to, rather than some more general point about Part 5 and POCA. It certainly is right that cash proceedings are in the Magistrates' Court, but given the observation or the submissions that the learned friend has made about that case, all that the Magistrates' Court have jurisdiction to do in respect of cash is, one, make order that the cash be detained, and two, in the event that the court is satisfied that the cash is falls into one or other description of recoverable property, that it is that it may be forfeited. So it's a narrow jurisdiction. It's not required to determine who it belongs to necessarily, although often that will be an issue. The question is it property that derives from unlawful conduct on the one hand, or is to be used for unlawful conduct on the other? So one is backward looking, the other was forward looking. So the point about summary cash proceedings in the Magistrates' Court is that they're not there to determine every issue. In one sense, the issue that Mr. Capper wanted to be determined, one can see this in the flavour of this in the decision of Mr. Justice Lewison. What the Magistrates' Court would have to decide in the event of an application for forfeiture rather than merely detention is whether the cash, whoever it belonged to, was recoverable, whether either it derived from crime or was to be used for crime. And in that context, the only reason that the court found that the application was made, given that, like this one, there was no dispute as between Kappa and Cheney, was to be able to deploy the determination, the declaration, in the magistrates' court when and if forfeiture was sought. And again, a bit like under Part 2, that declaration of itself wouldn't secure the release of the property, because even if it, although Mr. Kappa did have the right to apply for its release on the basis that it belonged to him, that's not a complete answer. But it can't sensibly be suggested that Part 5 of the Act ousted, I think was the terminology used by the master, ousted the jurisdiction of the High Court in relation to cash, because cash is property like any other property. And in the event, and had there been a valid and separate reason for a determination, perhaps because Mr. Cheney had refused, said, well, come what may, I'm not going to give this money back to you, or following a forfeiture application, unsuccessful forfeiture application, he demanded the money back. Well, of course, that wouldn't be a good example because that's after the event, but even during the currency of it, can't really see that it would ever be of any purpose for Kappa to have pursued an application. But my point is not so much the convenience, but the whether Part 5 itself and whether excluded that, and whether Mr. Justice Lewison thought that it excluded that. Then it's our submission that he didn't, because that's not what Part 5 does. So then, paragraph 17, and referred to, is where Mr. Justice Lewison said the master may have been justified on the basis of the authorities presiding before him, and that's where it goes into autologic. At the bottom of the page, in the present case, Parliament has resolved the resolution of disputes about cash alleged to represent the proceeds of crime to the magistrates' court. In other words, a narrow jurisdiction where it represents the proceeds of crime, not every issue in relation to cash. Mr. Kappa's claim in the High Court to ownership of the cash is an indirect way of seeking to achieve the same results that would have been open to him by presenting his case, top of page 343, in the Magistrates' Court when the Commissioner's claim to forfeit the cash is determined. On that basis, as Lord Nichols said, it's an abuse of the process. So the judge's determination on the central issue was that it would be an abuse of the process, not on the basis of exclusive jurisdiction, because there isn't exclusive jurisdiction. There wasn't exclusive jurisdiction under Part 5 either. It's that the purpose of it was seeking an advantage.
Mr. Evans, I wonder if that can be right, because he's dealing with it in descending order. That's his first point, paragraph 19. Then he talks about the principles of residual discretion. And then at 21, 4 lines in, he says, thus, even if the Magistrates' Court does not have exclusive jurisdiction, the High Court ought, as a matter of discretion, to decline jurisdiction. So his first point is exclusive jurisdiction. That's the point up to paragraph 19. Then paragraph 20 is it should have, if it was discretionary, it should have been exercised against Mr. Kappa.
Well, my lord, accepting that for, and in terms of the structure of the judgment, that does look to be it. But
yeah, we
particularly rely on, and say this is the important point as far as this case is concerned, as a matter of that even if it's not a matter of exclusive jurisdiction, the High Court ought, as a matter of discretion, to decline jurisdiction.
So essentially you're saying paragraph 21 is good enough for your purpose?
It is good enough for my purpose. And that's why it's so important that the judge made the findings he did in relation to the true nature of this claim, because we submit that this makes a wider, or is good, or is support for the wider proposition, which is also echoed, at least although in an entirely different context and at a different stage in Hunter. And just on that point, because I need, I think, only refer to two paragraphs in, or want only to refer to two paragraphs in Hunter. The first is at the beginning of Lord Diplock's speech, which is on internal numbering 536 from C to D. The simple point, not, I think, controversial, the circumstances in which abusive process can arise are very varied. And perhaps I should have started that beginning. The abusive process concerns the inherent power which any court of justice must possess to prevent misuse of its procedure in a way which, although not inconsistent with literal application of procedural rules, would nevertheless be manifestly unfair to a party to litigation before it. And this claim, though not inconsistent with the literal application of the rules, and indeed section 58 says otherwise, is nevertheless a case where we respectfully submit. Back to this case.
Could you just give me the reference to that you referred to in Hunter?
In Hunter, my lord, yes, page 536, which is the very beginning
Yes.
of the speech of Lord Diplock.
Would accept, I think, that those sorts of notions, manifest unfairness and so on, is not something that the judge addressed.
No, but he very much did take, although this case wasn't cited by either of us, the second part, which or the second point that I wanted to make, which is page 541 at B. The abusive process which the instant case exemplifies is the initiation of proceedings in a court of justice for the purpose of mounting collateral attack upon a final decision against the intending plaintiff, which has been made by another court of competent jurisdiction in previous proceedings. Now, whilst that, as I say, it was a different stage because the defendants, notoriously in Hunter, had been convicted in the Crown Court already, and my lords know the circumstances of the
I
case.
must say, knowing what happened later, this doesn't look so good.
No, no, it doesn't. But not ignoring what happened later,
Yes.
but the point here survives, notwithstanding the belated quashing of the convictions. And then there's a second paragraph on the same page, which starts with this delightful sentence. It would call for a degree of credulity too extreme to be expected even from judicial members of your lordship's house, which is a pleasure to read. But it goes on to say, after the reference to the Birmingham bombers, talking about the proceedings being brought in an endeavour to establish long after the events, when memories have faded, and really have nothing to do with the damages claim, which was the nature of the claim, was a purported nature of the claim. So here, and we would respectfully submit similar cases where the only purpose is a collateral purpose. And even if, as Lord Diplock said, it's strictly within the procedural rules, even if it is not excluded as a matter of express statutory law, that nevertheless it will be an abuse if that is the sole reason. And perhaps a final circle round this issue, consistent with what was said in the postscript, arguing against myself, in the postscript of Lexi Holdings. There might be circumstances where all of the other ways of resolving an issue in relation to restraint, for whatever reason, the Crown Court thinks are impossible. Perhaps because as in, not as in Lexi Holdings, but as in Stamford, there's massive other litigation going on already in the High Court in relation to the property. Although actually the right answer is for the High Court judge who's dealing with all of those other issues to sit as a circuit judge pursuant to Section 8 of the Senior Courts Act to deal with the property-related matters.
Irrelevantly, I might say the only time I have ever sat in the Crown Court was when I sat in the Crown Court and the Chancery Division at the same time for this sort of purpose.
Well, but that, with respect to a useful example, because that's exactly the sort of thing that does happen, and not infrequently, and particularly in more complex cases. But that would be. But I said I was arguing against myself. It might be, and certainly one can never say never. There may be circumstances where you say, well, for whatever reason, we're not going to do all of that. But nevertheless, it would be useful to ask the High Court to make a declaration on this issue, and then to adjourn whatever proceedings there are in the Crown Court. Well, in that case, it wouldn't be an abuse. But it wouldn't be an abuse because it'd been sanctioned, indeed directed, really, by the Crown Court, exercising the primacy that Lord Justice Hughes talks about in the Stanford case at paragraph 126 on page 333. Well, that was another diversion away from, or distraction away from Capron Cheney. But we say, in short, that the real point, and what we rely on Capron Cheney for, and did in the court below, was that the court is, as a matter of discretion, declined jurisdiction. There's the paragraph I've already referred, paragraph 21. There's also another reference to that at paragraph 25, page 344, which we say is this case. In my judgment, this is between F, just above G, at the bottom of 344. In my judgment, the use of the procedural machinery of Court A to achieve a result in Court B, where Court B is a domestic court of competent jurisdiction, is properly characterised as a collateral objective. And that is what we respectfully submit the judge here did, or relied on Capron Cheney for. Mr. Justice Michael Green regarded the instant case as exactly an example of that, and we submit he was right to do so, and it's not said on behalf of the claimant that his characterisation of the claim was anything other than correct. Well, although it was only, I don't mean this with any disrespect, it's a passage, it's a sentence indeed in the skeleton argument with a friend in relation to the misgivings that the defendant, or the claimant I should say, might have in relation to the Crown Court. There's a real issue we respectfully submit if in a case such as this, there is encouragement to leave the Crown Court and issue proceedings in this court to achieve what could, and we respectfully submit should be achieved in the Crown Court. There's been a certain amount of going round and round. I hope not the houses, but unless I'm not inviting further
if you're not
questions.
going to blame Lord Justice Coulson, you better blame me. I've got one more question.
No, afraid not. My lord, yes.
Is there a difference between the adversarial nature of civil proceedings and the nature of POCA proceedings as between the CPS and a third party? Because third party is not tarred with the brush of criminality, is not made a party in any respect, is only allowed to make representations in circumstances where, as you conclusively, to my way of thinking, shown, POCA proceedings are not about establishing or changing property rights. If I can put it this way, they're about getting the right answer.
Yes.
And it goes back to something I asked right this morning. It just seems to me to be a difference which we haven't really pinned down. Maybe flowing from the fact that CPS is a governmental instrument of justice rather than just a straightforward adversarial litigator. Your CPS's primary concern is with the defendant, and other people get caught up in this under a regime which everybody acknowledges is a draconian regime in many, many respects, to put it mildly. Is there a difference? Is your position vis-a-vis the third party in any respect different from being purely adversarial in the way of civil litigation is understood, or indeed the way that the prosecution of a defendant is understood?
If there is a difference, we would respectfully submit it's to the advantage of the third party.
Should be.
Yes.
But I can't work out what the difference is.
No, well, I'm hoping I may be able to at least provide some comfort. Two reasons. That precisely because the proceedings as between the Crown and the defendant are adversarial. So, not though in relation to a third party. It was already observed that the Crown Prosecution Service and any prosecuting authority in relation to Part 2 of POCA has to act as the Minister of Justice. And because Section 69(3) demands that third party property rights are respected. And certainly, not giving evidence, but certainly it's the experience of those who practice in the field that the issues of third-party property rights are taken extremely seriously in the Crown Court, and it may be that they have the advantage of being independent of and separate from the defendant, or for there being a straightforward claim, because a straightforward civil claim, not least because ultimately the Crown Court can only make, well, it can make a confiscation order, which is a money judgment anyway, but it can only clothe an enforcement receiver with a power to sell property to sell it, but has to account to any third party for the value of his, her, or its share of interest in the property. And that's freestanding. That's not a matter of a dispute in a civil claim, however it's framed. It's because that's what the statute demands. So we would respectfully submit that it's actually better because statute requires an approach to be taken. I should also say that enforcement receivership proceedings under Part 2 are also, relatively speaking, a rarity. But at any rate, they are very much less common than restraint orders for a number of fairly obvious reasons. They've already adumbrated at the beginning. The defendant may not be convicted. The the benefit may be lower than the value, the order may be paid off. But it's at the stage, critically, bringing in sort of A1P1 type issues, critically at that stage, Crown Court can only make an order and allowing, well, if it allows the receiver to realise property, the receiver must account to a third party for the value in exactly the same way as would happen in the event in the case of a legal charge secured against property.
Can I just ask one entirely irrelevant question, I think, but sort of supplemental to my lords this morning? Suppose you had a case where the ownership of property was fought out in the Crown Court as between the CPS and the third party, in effect, and the CPS won. How does the cost position work then? Do you get your costs against the third party?
Yes.
Yes, I see.
Yeah, because
Again, costs follow the event.
the costs follow the event. It doesn't apply in relation to a defendant, but yes.
Yeah. Thank you very much,
Those are
Mr. Evans.
submissions.
Mr. Warwick.
My lords, I've got 3 very short points.
Sorry, but Lord Justice Coulson reminds me absolutely correctly. I was going to check whether Mr. Tatum had anything he wished to say. I rather suspect that he won't. But Mr. Tatum, is there anything that you would like to say at this point?
Not at this point. Just one quick little thing. To what I've been listening to today, and obviously find it really interesting. Listening from the prosecutor's side, that saying that Mrs. Ahmet has got a fair chance of in court having a hearing set. I can't see how, because at the moment, how I believe it is, she's been separated from the party. She's got interest in the house. They're saying that she's got no interest at all in the house. And she's got no fight in how she can have interest in the house if it goes back into the Crown prosecution, when it goes back into the Crown Court. She's got no argument. If that makes sense, Your Honour.
I think Mr. Evans would say, well, she's perfectly well placed to argue her case in the Crown Court.
Okay. It's just obviously listening today what the argument is from the Crown prosecution. She's had no fair hearing of what she's been through, you know, since obviously my arrest. How we've gone apart from each other is because she didn't have any clue about my crimes or anything to do with it. So as far as she's concerned, all of a sudden now she's gone from a housewife into a full-fledged of her finances, and now she has to fight for everything, which I can understand.
Yes, I see.
And from what I see, it's not even being looked at from her side. It's all about what they're going to try and take off of me and get as much as they can. So for her argument in court today, I can really understand why she's in court today, fighting for everything that she's trying, to try and prove what she's got financially involved in mine. Obviously, because I'm on paper at the moment, it doesn't look like she's got anything. If you go back in the years and the evidence that we've got, we've built a big lifestyle up together, but we hit, obviously, during the COVID, we hit a crisis where I had to remortgage the house, and because of her credit rating at the time, she wasn't credit scoring to remortgage with me, so I had to take her off of the deeds, which in my hindsight now is one of the most stupidest things I've ever done, is take her off the deeds, because if she was on the deeds now and she was 50-50, we wouldn't be where we are. But if you go back in time, she bought everything with me, all our properties and everything else were built together. But during that COVID time, obviously the pandemic, we was in financial difficulties. So remortgaging was the only thing we could do. To do that, she had to come off of the deeds. Well, now that has been a big problem all the way through, because it doesn't look like she's got any involvement in the house at all. So obviously today is a big hearing for herself. For me, I've sat back, I'm not arguing anything, because I believe she's entitled to what she goes for. And I believe the prosecutor said that I've had no involvement in this because, one, I haven't had any access to before in the hearings, and two, I'm not fighting anything because she's the mother of my children. She's got rights for her to obviously have a financial involvement in all this. Now she's had a financial restraint, the same as myself. She's all her assets and her bank accounts were frozen. She's had to go out there now. She's lucky she had her own business, and she's managed to. So I don't know how she's done it through post. She's got the money together to pay the bits of mortgage and survive. So it's for me. I've not got no say in anything, or I've got no say in whether what she deserves or what she doesn't deserve. As far as I'm concerned, she deserves everything she can get, if she can get it. That's all I've got to say. Thank you.
Thank you very much. Just before I ask Mr. Warwick to reply, Mr. Evans, there's nothing arising from that you need to comment on. No. Thank you very much, Mr. Tatum. Mr. Warwick.
Thank you.
As I indicated, I've got three very short points. The first is to reflect on a point that my learned friend Mr. Evans made, I think, twice, which is expressing a concern of the SFO getting drawn into civil proceedings. But inevitably, we're here talking about issues involved with the property. And if the SFO is contending that the defendant has any interest, then it's obviously drawn into that issue. And this court is concerned with whether my client is debarred from issuing proceedings of any kind. Effectively, my learned friend is repeating a cri de coeur that was put before the House of Lords in Norris. You've, I think, been taken to that passage more than once. It's the passage at the bottom of page 180, where the customers have urged their lordships to dismiss the appeal since it would be an inappropriate hindrance in the enforcement of confiscation orders. And that's the same submission. It was rejected, albeit that legislation was obviously changed somewhat, on the basis that the normal civil procedures should apply. Now, that general approach has been reiterated very recently in Aquila, and your lordships are being asked to say, no, although third-party rights are thoroughly to be respected and not interfered with, somehow, if you want to assert those third-party rights, you can only do so in the Crown Court. And that seems, we submit, wrong. Second point is totally different from that. There was a question asked, in fact now a couple of questions asked about costs. We've checked the rule 3347 so far as we can online, and we agree that where you have an application to vary or discharge a restraint order, then there's power, rather like the CPR, to order costs. There was a question asked just now about confiscation proceedings. We haven't yet found the provision in the rule, so I wouldn't want my silence to be construed as agreeing that there's a sort of CPR approach applying to confiscation proceedings, because I can see that applications to vary or discharge a restraint order are sort of freestanding. Quite where you are when you've got confiscation, I don't know. So I don't accept or dissent, but flag that out as a query.
Could we have the benefit of an email setting out an agreed position after today?
Certainly, certainly.
So,
The last point is my learned friend's reference to Hunter. As it happens, we don't need to look further than Norris to see what the impact of Hunter was down the road. In Norris, it's page 179, paragraph 26. The principles applied in the cases of Hunter and Ashmore do not apply. And then you've got, in Hunter, the plaintiff was engaged in trying to relitigate in a civil court a factual issue which had already been decided against him in a criminal case in which he had been a party. It involved a collateral attack upon a decision in previous proceedings in which he had been a party, fully represented, complete control over the evidence he wished to put before the court. None of those sentiments apply in this appeal, because in this appeal, we're concerned with civil proceedings initiated by my client, summarily determined by being struck out. So there's not been any decision. We say that Hunter has no application. It's only been mentioned by my learned friend at the end, so I don't perceive it to be a second anchor for his submissions. But I certainly suggest it has no basis for this court's decision. Those are my 3 points.
Thank you very much. Thank you both very much. Thank you to to your juniors and others who've helped with the presentation of these cases in which we've had very helpful submissions. As you'd anticipate, we will reserve our judgment in accordance with what is now the practice. The judgment will in due course be handed down electronically rather than in a courtroom. Again, in accordance with normal practice, in advance of that, you will be supplied with the judgments in draft. And I haven't checked, but I assume you've supplied the list of appropriate email addresses. And that, of course, is for you to correct our English and typing, but not to re-argue the case. Also, in advance of the hand down, we would be grateful if you would seek to agree an order dealing with consequential matters. If there are points on which you disagree, we'd be grateful for brief written submissions, and we would expect to rule on the points in the order that we make. And lastly, echoing what I was saying just a moment ago, I'm sure you're very well aware of the importance of the embargo, but we would stress it once again. But thank you very much.
All rise, if able.